Some people may wonder why is South Korean is speaking here in Brazil. I have some reasons because Korea is one of the a big global player in terms of the IP and content laws enforcement. Especially as I was invited to speak at the ABA conference in London yesterday in the so-called IT industry smartphone world. We have a very strong players, and our enforcement and legal principles is heavily debated in the world, especially in comparison with the German and the American court decisions. But in terms of the pharmaceutical industry, the situation is different because we don't have a big player in Korea. And in case if I am allowed to say that in the smartphone world, the Korean companies are some entity to harm others in the pharmaceutical world, we are the party to be harmed from the big player. So that's one of the important parts of why we have this case. Now, Professor Drexler just said that why killing number one competitor is important, and let me present why it is important, because this is the case. Okay, the generic drug is important in Korea too, as anywhere else in the world. The price of the generics is tend to be lower than the original brand drugs. If I say it is 80%, well, it should be much higher than the case in Europe or US, but it is still important gap. And why we have been experienced that so high price of the original brand drug and generic drug is partly due to the obligatory national health insurance system, where drug price is not a main concern of consumers or the pharmaceutical companies, because the price of drugs is negotiated between the pharmaceutical companies and the National Healthcare Review Agency. But because we have a very serious problem of a financial, worsening financial status in the national health system, keeping a drug price lower is one of the most important policy goals for the health department. So, in Korea, we don't have, the so-called now exclusive right to sell first generic, as we see in the case of the United States, and we don't have an ANDA system too. Well, we are trying to introduce the abbreviated review system, but it is faced with very strong resistance, and some people like that because there have been some problem of the reliability of that abbreviated review system. So, but in 2015, in less than 1.5 years, we have promised to introduce the so-called Hatch-Waxman system in Korea. So in fact, because of the general worries about that, sweeping effect to the national health system, the introduction is delayed for 3 years, but we cannot avoid it anymore. Because we have promised with the United States government when we signed the FDA. So this case regarding the GSK is important because not only because of the current situation, but we are expecting a enlarged incentive to block the entry of the generics in the future from 1.5 years afterward. Okay, let me go into the facts of the case. and GlaxoSmithKline has developed ondansetron, and they developed and sold the trade name of Zofran that is known to be intended to treat nausea. And they have applied for a patent in 1985 and registered in 1992 and started to sell Zofran from 1996, and it eventually took nearly half of the market. The Dongha is Korea's #1 pharmaceutical company, and it is important because it has extensive, strong distribution of drugs in Korea. So that is why the killing #1 is important, right? So they have started to apply for and develop a similar generic drug and applied for a separate manufacturing and method patent in 1997. And they have stated that they have developed two different processes, and they were registered in 1999, and they started to sell the trade name Ondaron eventually. So Ondaron is a generic to Zofran. Now GSK has sent a warning letter to Dongha that you have infringed my patent, and Dongha filed for a counteraction, and they filed a complaint for a passive trial to confirm the scope of its patent. That means that please confirm that my patent does not infringe this guy's patent. This case was filed at patent court, and GSK filed another infringement action in the Seoul district civil court. So some months ago, afterwards, GSK and Dongha, they have signed 3 different agreements. #1 is conciliation settlement agreement to settle the dispute, and both parties have agreed to finish all the legal disputes, and we are not going to file another filing complaints. Okay, #2 agreement is about the ondansetron, that is API, active ingredient of the Zofran and Ondaron. And GSK has granted national public hospital sales. That is a big part of the sale of that drug. And they have granted the exclusive right to sell to Zofran to Dongha Pharmaceutical. And GSK also gave significant incentive for high sales of performance of sale of Zofran. And Dongha shall not develop, produce, sell any medication similar to Zofran. That's what they have agreed. And #3 agreement is exclusive sales right of Valtrex. Important part is Valtrex is a drug to treat herpes, a skin disease, and it has nothing to do with the Ondaron or Zofran. So it's completely different, and it was something that is not yet sold at that time. Anyway, GSK have promised the exclusive sales right of Valtrex to Dongha, and in addition, GSK have agreed to give every year 70,000 euro. And Dongha promised again not to develop similar drugs to Valtrex. And those agreement has been, the first initial agreement has been signed for slightly been excessive of the patent period, patent terms, but it is afterwards renewed explicitly and implicitly, and until the present, the case was tried at court. So, KFTC has been inspired by the European Commission sector inquiry, and they have started the sector inquiry in 2010, and they have found that they have signed those 3 agreements. So they have started a formal investigation and issued corrective measures and levied some fines. That is not that big because of the small incentive. Anyway, the case was appealed to the Seoul High Court that has an exclusive jurisdiction over the KFTC's decision, and it was mostly dismissed in 2012 last year. It is currently pending at the Korean Supreme Court. And the issue is, number one issue is whether it is the settlement is a justifiable exercise of the patent rights. The Article 59 of the Korean Constitution law, it states that the justifiable exercise of an IP right is exempted from the application of Korean Constitution law. Okay, in terms of the reviewing the liability of the exercise of the apparent exercise of IP right, the Article 59 is always contested. It is heavily debated, and the issue is whether justifiable exercise, what does it mean? And then in this case, the Seoul High Court they have depended upon the scope of the patent test that is a traditional test that has been adopted by the many federal circuit courts before the activist decision. And the Seoul High Court also explicitly acknowledged the efficiency of patent dispute settlement while conscious of anti-competitive potential also. Right? So what they say was that, well, we understand the settlement is efficient and settlement itself cannot be a violation of any relevant laws. But their ruling is here, the provision prohibiting the production and sales of Ondron, that is a generic to the Zofran, can be a valid exercise of patent right itself because there is no clear evidence of invalidity or infringement. So, well, you can settle because no one is sure, and you can avoid the risk by signing settlement. But the three agreements was beyond the justifiable scope and cannot be deemed to be a valid exercise of patent rights because, number one, the original agreement also stipulated the prohibition lasted 3 more months, to be precise, 3.5 months, and after the patent expired in 2005. So it goes beyond the original patent rights. And number two is that it prohibited production and sales of products. They could have been produced in different methods on the Centrum. So it prohibited far beyond the original patent terms. And number three, it restricted again the vouchers, the generics that has nothing to do with this case on the merit. Number four, it is one of the important part, it is that, well, you have given the donga a considerable benefit, and that is beyond the normal magnitude that has been in the Korean market. So it can be presumed anti-competitive because you have given an excessive economic benefit. So in constructing reasoning of the ruling A, the court said, if a party acknowledges that it has infringed upon another's patents and raised measures so that there is no further infringement, even if there is later determination that there is no infringement, it's okay, just as I said, because it is a valid exercise of a patent right to sign a settlement. However, there is an exception. The conduct can be unfair exercise of patent right and subject to constitutional laws because it is not justifiable exercise of IP rights is, number one, if it is obvious that the patent at issue is invalid or that the competing enterpriser has not infringed upon the patent and the patentee and the competing enterpriser agreed to limit competition in the market, right? When it is obvious, well, you cannot do that. Number two, if any such agreement stipulates that the competing enterpriser shall not release related products even after the patent expires, as was this case, it is not justifiable. And number three, in cases of method patent, if any such agreement prohibits the research, production, and sale of products similar to the product produced by the patent method, regardless of the production method. Right? And number 4, if any such agreement prohibits research or experiments that the competing enterpriser could conduct without patent infringement until the expiration of patent, so that the competing enterpriser cannot release products immediately after expiration of the patent and in fact extend the monopoly of the patentee. Right? You have delayed the entry. And number 5, if any such agreement prohibits the R&D or release of related products that have no direct relation to the patent at issue. So you can see that everything, every exception, it concentrates on the delay of the entry of the generic drugs. Okay, number 2 is about the anti-competitive effect with regard to Andron and Zofran. The court said that the agreement to restrict production and sales of competing product Andron, even after the patent expires, is a violation. So the reasoning is just like issue 3. So regarding the anti-competitive effect again, restriction of Dongha's R&D and production of medication in potential competition with Zofran or Valtrex is found anti-competitive, and because joint marketing is okay, but there is less competition restrictive ways, right? In the world of competition laws, you have a general kind of a responsibility to opt for the less or least competition restrictive ways if it exists. The conclusion is that one of the big issues debated in this case is whether the so-called reverse payment is possible scenario in Korea. I understand that in European Union, the similar issue is debated too, because we don't have the Hatch-Waxman Act system yet. But one thing I have to emphasize that in the competition laws, what we have in mind, the most important thing is the consumer harm. Well, the patent settlement is, in usual cases, it is legitimate and it is natural and acceptable. But it is acceptable and legitimate only when the interested parties are on the table to negotiate, right? In the scenario of the reverse payment, well, there are 3 parties: the originator, generics, and the patient, the consumers. And only the generics and the originators are on the table to negotiate the entry of the generics. But the consumer welfare is not their concern, right? That is the problem the Commission Authority has in mind in everywhere, in Korea, Europe, and the United States too. So it is, as far as my understanding goes, generally agreed. The pay-to-delay or reverse payment is a possible theory even in Korea, where exclusive rights for first generic is not established yet. The problem is only the size, magnitude of the incentive to delay the generics. But as you saw, we don't have such a great incentive to delay the entry of the generic. But by blocking the number 1 competitor, it can harvest a certain profit. So that's the conclusion of the both panels of the Seoul High Court, and whether it is correct or not will be reviewed by the Supreme Court. So introduction of exclusive rights, as I said, will be allowed in 1.5 years, and I believe that the Supreme Court of Korea will consider that imminent future into their consideration in designing the relevant laws. As you saw, this case itself is very simple because even if we apply the traditional scope of patents right test, well, it is still illegal. So my understanding is that it is the reason why the 2 panels of the Seoul High Court, they have reached an identical conclusion. But the arguments from the GSK and Dongha is that, especially from the side of the GSK, they've argued that if this is not a reverse payment case because Dongha's infringement on the GSK's patent is very clear, 100%. So it cannot be a reverse payment because the reverse payment is initiated to remove the risk of being his patent non-infringed or void. But the findings of the KFTC and the Seoul High Court, they do not agree. So, well, how are you sure that they have 100% infringed upon your right? So, KFTC was successful in that. So, as I said, we are waiting for the decision by the Supreme Court, and I believe that the activist decision by the U.S. Supreme Court will be of great reference to Supreme Court of Korea. I'm not sure. I have no idea which direction they will go. They can just confirm the Seoul High Court's decisions, or they are able to introduce the so-called rule of reason, or I think it is the activist decision is something like between this rule of reason and quite a quick look. And current Supreme Court might introduce that the legal principle of the activists into Korea. So, but regardless which test is adopted in Korea, the critical factor could be the reverse payment amount, especially if we accepted the rule of reason test. Well, if we accepted the scope of patent right test, well, it is not that important, right? But if it depend upon the rule of reason test, the amount is of great importance. But the situation in Korea should be different from Europe or especially from the United States, because the litigation cost itself is substantially lower than in the United States. So my understanding is that in the case of the GSK and Tonga, why the economic benefit delivered to Tonga was considered excessive and far beyond the market custom, is that because of the lower litigation cost and because of they had less incentive and because the market was considerably small. So I think this is all I can say for now. And one last thing is that one of the arguments that the GSK has argued that, well, because we don't have an exclusive seller rightship, we were not able to block number 3, number 4, number 5 generic companies enter the market, and it was a fact. And how can a competitive effect has been involved in that situation? And the finding of the whole High Court was that, well, you have removed the number 1 distributor, and without that kind of conduct, the market competition should have been more active than now, and the price has been proved to be a little higher than before. So that's the conclusion, and I think this is all. Thank you.